Now, let me paint the scene for you. Courtroom packed, the tension thick, and at the center of it all, Advocate Mshololo in full beast mode, cross-examining Warrant Officer Ndlovu like a detective on caffeine. She didn't waste time, straight to the jugular. Were you the one who took these photos? Ndlovu, quiet and composed, says, no. Boom. Right there, she created distance between him and the actual evidence, because in any court of law, especially under Section 3 of the Law of Evidence Amendment Act, it's not just what you present, it's how you obtained it and who handled it. Mshololo was making it very clear this officer wasn't the originator of the photos, nor the one who verified their contents. He was simply the data delivery guy. Imagine getting WhatsApp screenshots from your cousin's ex and then being asked to swear that they're legit. That's basically what was happening. So already we have a problem. Ndlovu didn't capture the photos, didn't analyze them, and didn't verify them. He just transferred them like a glorified flash drive. And in legal terms, that's a shaky start to any evidentiary chain. Now, imagine you're told that someone committed a crime in 2014. You ask for proof, and they give you a printed picture with no date, no location, and no idea where it even came from. That's literally what happened next. Advocate Mshololo pointed out that the photos presented as evidence had no metadata, nothing to show when, where, or even which device captured them. And this isn't just a tech issue, it's a legal landmine. South African law relies on authenticity of digital evidence, as outlined in Section 15 of the Electronic Communications and Transactions Act, ECTA. If the image lacks metadata, the court can't verify its origin, so how are these photos still in court? Warrant Officer Ndlovu agreed. Yes, the images had no timestamp, and worse, the originals had been deleted. The court was now looking at duplicates, copies. You know, like when you photocopy your ID 5 times and now it's just a blur? Yeah, that. And here's the kicker. Even forensic tools couldn't find hidden data in the image files, which means no verification, no source, no chain, just vibes. Okay, now here comes the jaw-dropper, the moment that had Twitter shaking. Advocate Mshololo, cool as ever, drops the million-rand question. Are you aware that images like these can be edited? Ndlovu, without skipping a beat, replies, yes, I know they can. I can also do it myself. Wait, you can. You have the skills to edit court evidence. Guys, in any other job, that's like a chef saying, yes, I can poison food. I just didn't today. My God, why would you admit that? But in legal context, this is massive. Under South African criminal law, especially when digital evidence is in question, admissibility depends heavily on its integrity and authenticity. Ndlovu's admission opens the door to reasonable doubt, a golden ticket for any defense team. And let's not forget, we're not just talking about cropping here. Today's photo editing tools can change faces, dates, locations. Heck, AI can make you look like you were on the moon. So when Ndlovu says, yes, photos can be edited, the court should be clutching its pearls. Now, let's talk about that red shirt, because if this trial were a movie, the red shirt would be its own character. One image, supposedly from 2014, showed a man in a red shirt. Another photo taken in 2020 showed a very similar red shirt. And guess what? No dates. Again. So Advocate Mshololo asked, how do we know when this photo was taken? And Ndlovu, man, looked confused. It's like someone asking you when you last wore your favorite hoodie. You think you know, but do you really? In the world of digital evidence law, especially in criminal trials involving life sentences, this isn't just a fashion issue. This is about proving presence. If that shirt places the accused at the crime scene, the date must be locked in tight. No guesses, no assumptions, no, maybe it was winter, but Ndlovu couldn't tell the court when the photo was taken, or even if it was from the right year. At this point, it's like watching someone trying to solve a puzzle, with half the pieces missing. All right, now this part is where legal alarm bells start ringing. Mshololo turned up the heat. After you created that USB drive, who handled it next? Ndlovu. I don't know. Where was it stored? Ndlovu. I'm not sure. Could it have been altered? Ndlovu. Shrugs. Folks, that's a chain of custody breakdown if I've ever seen one. In South African law, a proper chain of custody means you know exactly who had access to evidence from the moment it was collected to the moment it's shown in court. If there's a gap, the defense can argue tampering or even outright fabrication. And let's be honest, if you lost track of your laptop for one day, would you still trust all the files on it? Now imagine doing that with evidence in a high-profile murder trial. With Ndlovu's vague answers, the state is basically telling the court, just trust us. And that's not how justice works. Not in a system that depends on proof beyond a reasonable doubt. And then, just when you thought this testimony couldn't get more chaotic, Ms. Mshololo hit the finishing move. Are you an expert in digital forensics? No. Can you confirm if these images were edited? No. Ladies and gentlemen of the jury, that's a wrap. Death. Warrant Officer Ndlovu admitted he is not trained in determining whether digital images have been manipulated. According to Rule 36 of the Criminal Procedure Act, expert testimony is required when presenting specialized knowledge, like digital forensics. So Ndlovu, who moved these photos around and submitted them as evidence, had zero qualifications to assess their authenticity. And with that, Ms. Mshololo basically told the court, this man shouldn't even be on this witness stand. Mic dropped. This is the end of the video. If you enjoy our commentary reaction and would like us to provide more better videos, simply press like, subscribe, and leave a comment below. Let's meet on the next video.
Thank you. And also the fact that I'm going to accept the date that we have testified about here in this court to say these pictures were taken in 2020. So, also as a human being, you cannot then say, because these pictures, because this person looks like this during the period of 2020 when these pictures were taken, it means it's the same, it resembles the same features of the pictures of the same person during the period of October 2014.
Now the witness is invited to argue. It's an unfair question to the witness. Let's go, please.
My Lord, I did not hear the basis for the objection.
Just repeat your objections.
Counsel is inviting the witness to argue the case for the state. That will be for the state to argue.
All right.
Not for this witness to comment.
Yes, the court pleases, my Lord. My Lord, if I may respond, it's because the witness was taken through the pictures, if I may be specific, my Lord, and not be general, through exhibit DD4A, with the comparison of a picture, my Lord, which was of an identification kit, which was taken in 2014. And the witness was led regarding these two pictures, my Lord.
What does it say about the one picture which was in the identification parade? This witness, what does it say about it?
My Lord, the witness was asked to give description of these pictures to say...
Not the clothing or the apparel?
Yes, to give the identification of these two, and the witness even said...
Is it the clothing or the facial?
Because
you're arguing that he's not a facial expert.
He gave both, my Lord.
Facial?
Yes, my Lord.
And then the apparel also, he's not an expert on identifying apparel.
Apparel,
Yeah,
yes.
put it to him.
No.
When you say wearing a toga or a robe which is grey and red,
Yes.
it's putting it to you that you're not able to identify that.
No, my Lord, but that's not my question for now.
I thought you said even the apparel, you can't be able to identify it.
No, my Lord.
Okay, fine.
My Lord, I was responding to the objection, my Lord, to say the reason why I am entering into this field of evidence is because the witness had been asked to comment on these pictures, my Lord.
Yeah, fine, go ahead.
Thank you, my Lord.
Stakes ignite where the questions burn hotter than the night. No escape once you're locked in the heat. This is your trial on the hot seat. To the fire where the stakes ignite, where the questions burn hotter than the night. No escape once you're locked in the heat. This is your trial on the hot seat. Ticking clocks and a sweat-soaked scene. Can you handle the pressure or split at the seams? Truth or dare with no retreat. The sparks fly high on the hot seat.